All right, we are about to start our last panel for the BDC conference. Well, I can't think of a better way to close out our conference than to have Brian and Eugene, as well as Clayton. Up to Clayton's home. We're working on that. Okay. Clayton, you can see that his spirit is definitely want to be here, but he has some emergency that he's dealing with. But even that, he is calling in from the US. He's staying up late, so we really want to thank him for helping us out. So, without further ado, Brian, take it away.
Okay, thank you. This is our last panel, so we'll make it fun and painless, of course. Those of you who don't know, I'm Ryan Barshaw. I'm the chapter secretary of the Bangkok chapter, and I'm joined today by two esteemed colleagues. We have to my left, Mr. Eugene Chow. Eugene is a seasoned practitioner based in Hong Kong, and remotely we have my other esteemed colleague, Mr. Clayton Cartwright, who has recently been very active, involved in the GMS. As both Eugene and Clayton are extremely well knowledgeable and versed in the field of renunciation, U.S. citizenship, and of course tax purposes, tax issues. So we're going to cover both those issues. And to do this last panel, we thought we would do a bit of a role-playing situation. So if we have Clayton here, good, okay. I'm going to play the role of an accidental American. I became an American citizen because my father was studying for his PhD at Harvard. And I left the United States after my father got his PhD at Harvard. And I moved abroad to my country. And I am very, 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 very wealthy. And everybody loves me. I should know everybody loves me because they keep on calling me sir. And I have an army of household help. And my nannies who have been my household help, their mothers were the household help, and their mothers were the household help. So the whole family of generations has been my household help. I have many, many nice cars. I'm a member of the country club, and everybody loves me. I've been to the nicest, finest schools. And did I mention everybody loves me? Yeah, everybody loves me. And I honestly believe, because everybody loves me, that the law doesn't apply to me. Because in my country, what we do is when there's a problem, we just shell out some money and the problem goes away. So, I am the accidental American, but I've been told by my tennis buddy at the country club that I may have a tax issue. And I said, well, maybe if I can get rid of my citizenship, I get rid of the tax issue. So I go to the offices of Chow and Cartwright for guidance, and I pay them a consultation fee because I am very, very
great law partner.
He loves me. So let's continue. Let's begin. So I walk in, I get past the secretary, I give my American Express Platinum card for payment.
We don't take credit cards as well.
No, we don't either.
Cash only. Lots
Private
of
bank only.
Very wealthy, very lovely. And I get past the paralegal, and then I'm surprised. I thought I was seeing Mr. Chow, but apparently I see Mr. Chow and Mr. Cartwright in the same room. So maybe because I'm so wealthy, where he loves me, that's the reason why I'm getting two lawyers, the price of one.
Well, tax as well as immigration consequences. So we got the special guy all the way from Georgia phoning in so that we could bill you double. He's going to talk to you about the tax consequences of being an accidental American, while I talk to you about the immigration consequences.
Which is more painful?
Well, I think the tax lawyers often ignore or forget about the fact that when a person gives up his citizenship, he's like any foreigner knocking on the door trying to go back in. And a lot of times, people get all caught up with the tax consequences of exiting from the United States without taking into consideration post-expatriation what they should be doing.
How much is it going to cost me?
Well, depends on how complicated your case is.
Well, this is confidence, right?
Of course, attorney-client privilege. Everything is confidence. in confidence.
Okay, well, the law doesn't apply to me, so I never pay taxes. But I make a lot of money, but I don't pay taxes.
Wow. There could be criminal penalties or Clayton.
Even though the law doesn't,
I'm not going to put the fear of God in you, but Clayton is going to talk to you about.
Right. And so this is probably appropriate. Can you hear me? Everyone, can you hear me?
Yep.
Okay, great. So this is probably very appropriate that I'm out on the screen here like some Orwellian figure, okay? So from the perspective of the fact that the client's coming into the office and saying, well, gee, I've never filed a U.S. tax return. Well, it depends upon whether or not that individual actually knew. And Eugene whether they actually knew as the U.S. citizen, whether or not they were required to file such a return. And so to the extent that the person said, well, thanks for telling me, I never knew, and that the basis of that knowledge is reasonable, he's not BSing you from that perspective, then we have a discussion about bringing him into tax compliance going forward. And then we can go down an avenue of doing such a tax review to see if the person's in a situation where in such a situation, what would happen if the person gave up U.S. citizenship. And what I mean by that is that there's two costs that we look at here in terms of renunciation. The first cost is one of bringing the individual into tax compliance. When one gives up U.S. citizenship, a proper tax review involves looking back to see if the person's in compliance with filing their income tax returns or gift tax returns, not employment tax returns to the extent they have such an issue with the United States, and particularly, of course, the foreign bank account report, what's now officially called Treasury FinCEN Form 114. Always we call it the FBAR. And so the individual may come into your office and say, gee, I did not, I didn't know you performed the review. What if the individual comes in and says, oh, yeah, someone told me about that about 5 or 6 years ago, and I just sort of got around to dealing with it. So I thought, you know what, no big deal. I'm never going to go to the U.S. anyway, whatever. Then you've got a different animal. And so from that perspective, the different animal is one of criminal tax issues, such as what Eugene has mentioned. And so from that perspective, everything sort of goes into freeze from the standpoint of the tax lawyer in terms of the renunciation. Why? Well, it's a big fat practical reason why. Because you certainly don't want to be negotiating with the IRS, and I mean now, after September of 2018, which we'll touch on here. You do not want to be negotiating with the IRS about past due filings when you have renounced your U.S. citizenship. You've got a big, giant, fat monster target on your back when you do so. I would never want to advise a client to renounce if they've got outstanding criminal tax issues. Okay? I mentioned the second cost. The second cost, of course, is the exit tax. And we'll get into that a little bit later as well. But the question is, once you become into compliance with the U.S. system, is there going to be a cost to renunciation of citizenship? And there may be a cost. It may be that you trip the wire for one of those issues, in one of the 3 tests that cause you to pay a U.S. exit tax, or what's basically a deemed sales tax deemed capital gains tax on a deemed sale of your assets on the day before you renounce.
Well, now as the client, how much money are you making every year?
Well, is that how much do they know that, or how much really?
I think before we proceed, as Clayton pointed out, you are supposed to be in compliance for at least the last 5 years. And if you didn't really get much income because you're living off the largesse of your father, maybe filing the back taxes will not result in too much damage to you. Late payment penalties, so forth, interest.
Well, my father did, after he got his PhD at Harvard, he set up a big multinational company. And after I got my degree at a very, very expensive university in Asia, he did gift me and made me CEO, even though I wasn't qualified at all basically run a McDonald's, he did maybe qualify to run the big company because I'm the only son and he knows that he's never going to have heir. So he thought maybe he should gift it to me, which I didn't. He's gifted to me, and my salary is very high, and because, well, I don't really get a salary, I just take whatever I want for the piggy bank.
What is your tax rate in your home country?
I think it's 32%, if I'm not mistaken.
Okay.
Well, I think you've got to sit down with an accountant and work out what the damages are if you were to get back into compliance. But more importantly, have you been to the U.S.?
Well, sure. I mean, my family still has a very, very, very nice apartment in Midtown Manhattan, and we have a house in Nantucket, and of course we have our home in Palm Beach, and we have another home in
Palm.
area. So yes, we go there very often.
So assuming we get you back into tax compliance, have you ever done anything that, as an American, you could be a triple axe murderer, you can get on a plane and get back into the United States. Ever get in trouble with Harvard, smoking dope, drinking?
I don't remember. I had too much fun at Harvard.
Well,
actually, no, I remember I didn't study at Harvard. My father was studying his PhD at Harvard. I went to some really, really, really fancy schools outside the United States.
Okay, so have you ever gotten in trouble with criminal authorities anywhere in the world?
I think everybody knows about. I'm very wealthy, everybody loves me, and I can easily buy myself out of trouble. I've been doing it my whole life.
Well, just remember this, that expatriation is something very serious, and before you decide to move ahead to anything else, you've got to think through whether you need that visa to get back into the United States in the future.
Well, what would make me inadmissible? You mean just because I did something, and even though I bribed the police and they didn't file a charge against me, who's going to find out? Who's going to find out? We're living in the year 2018. Yes,
you were dumb enough not to hire Eugene.
That's what I do.
Well, you have the privilege of being an American citizen and never filling in a visa application form. But when you fill in a visa application form, they ask you all kinds of things.
Like what?
Like, have you ever been a polygamist? Do you have HIV virus? The most important is a provision, 212A10E of the Immigration Act, that says that any former citizen of the United States who the Attorney General determines to have renounced citizenship for the purpose of tax avoidance shall be inadmissible to the United States. Now, the Attorney General's role has been taken over by the Department of Homeland Security. But, if you decide to move ahead and give it up, and you want to go back to the United States, you're subject to review by a consular officer, something you've never gone through. You've got to fill in this very detailed application form, and you've got to interview. And if you come in, waltzing in with your country club look and being arrogant, remember the consular officer is the judge, the jury, and the prosecutor. So 212A10E is often ignored by tax lawyers, but I can tell you from practicing overseas for the last 30-something years that it is an issue that comes up in consulates around the world.
So in this situation,
Ryan, if I may, this is a critical point, because Eugene and I have co-counseled on this point before, and that is the reason for what Eugene is referencing is the Reed Amendment. Is it goes back to 1996 when the Internal Revenue Code was in congruence with the INA, and there was a provision from 2006 up through 1996 up through 2008, where you could show, based upon you could show on the tax return that there was a presumed avoidance of U.S. taxation by loss of citizenship. That's gone away. Okay, that's gone away since the exit tax has been put in 2008. But just because it's gone away under the Internal Revenue Code, the loss of citizenship with what they call the principal purpose of the avoidance of tax doesn't mean it's filtered away from the consulate post. This is a critical point. There's things that we see at the consulate post. I've seen tax materials at the consulate post that are 15 years old that don't even mention the exit tax. It takes a while for the bad information to filter out through the system. And so if you don't have somebody like Eugene, I'm not saying that you have to have immigration counsel coach the individual, But I'll be darned if my client's going to go into a consulate post and say, "Well, why are you giving up U.S. citizenship?" Because I no longer want to pay U.S. income tax. I mean, that is the death knell to say something like that. Maybe at most they can say that it's too expensive for me to file U.S. income tax returns. Perhaps the transactional cost of maintaining my citizenship to a country where I no longer have my center of vital interest. Maybe that's about as close as you want to get. But tax is a dirty word when you walk in and renounce. And so you don't want to say it or do it. And there's no problem with that from a tax perspective. The exit tax kicks in whether or not you have what you can kick in, whether or not, regardless of what your intent is now. That's been since June 17th, 2008. And so that's something that we have to make sure that we counsel our clients on, and make sure, of course, many of our clients, like to do their own internet research, right? Even the rich ones do. And so from that perspective, we have to make sure that they're clear that, walking to a consulate and not saying tax, it doesn't mean anything that you're avoiding U.S. tax by doing so. The chips fall where they may with the exit tax.
So let me ask you, Clayton and Eugene, if I give up my U.S. citizenship, is there really a chance I can be refused a tourist visa?
Well, just a few months ago, a business lawyer called me up because the 85-year-old lady gave up her passport about 6-7 months ago, and she wanted to go to her grandson's graduation from UCLA, and the officer said something to the effect that, "Well, you shouldn't have given up your passport because I don't have to give you a visa. It's a privilege to be an American, and I'm not going to give you a visa." 214B. What's 214B?
What is 214B?
214B is a presumption that anybody that applies for a visa, intends to have. It used to be that people that give up citizenship or green cards, they have the right to live and work in the United States. And once they give up that right, that's the best proof that they have no immigrant intent. But I heard there was some conference in Hong Kong, there were a bunch of consular officers, and they said that 214B isn't just about immigrant intent. It's that I don't like you. Well, not in those words. I don't think that consular officer said it. Right? I think that, the way you come in, I don't know. You're really going to act consistent with the tourist visa. Maybe you're going to have a wild time, smoke marijuana, party in the streets, drive sports cars. I don't think I want to give you a visa. 214B. You're not really a good faith business.
Oh, come on, give me a chance.
Well, this grandmother was told that come back, 214B isn't a lifetime bar. Come back and show us that you've got a home, you've got socioeconomic ties, you're going to abide by it. And this lady said that I haven't even been in the U.S. for 5 years. If it weren't for my grandson, I wouldn't even be getting a visa there.
So, what would be the benefit then of giving up my citizenship? I just, I'm going to inherit a lot. I'm going to inherit my house in Nantucket, the house in Palm Beach, the penthouse. I'm going to inherit a lot. You're telling me that I could risk never ever staying one night in the penthouse, or in the house in Nantucket, the house in Palm Beach, or the yacht?
Like, tell them what the possible criminal consequences are, in addition to being barred from the United States.
What, for failure to file? Yeah,
tax avoidance.
Right. Right. So yeah, the issue comes up, from the perspective of, I think, Eugene, what you're driving at here is the intervening question, or the intermediate question of, well, how are they going to find out? Right? Or, I'll keep my citizenship, and how in the world, if I don't file returns, or I only start filing concurrently, how will the Internal Revenue Service find out here? And frankly, this is a term that we mention all the time at BDC conferences, and that's FATCA, right? The Foreign Account Tax Compliance Act that is triggering over 90, maybe I think it's a little over 100 now, intergovernmental agreements on tax information exchange. There's one between the U.S. and China. And so from that perspective, congratulations. You now live in the world of 2018 and the world of big data, right? And so you tell your client here, okay, well, first and foremost, I never advise a client on how to evade the U.S. system. But they sort of ask the question indirectly. Well, it's a lot of costs that could be involved. I see that you're going to bring in the accountants or whatever, particularly if the individual's non-compliance has been what we deem non-willful, that they've known for a while and they've evaded. We're talking, prior to March of 2018, we were looking at least 2 years to bring such a person into the U.S. tax system. Now it may be much longer than that. And I say that because we used to have something out here, or we still have something called the Offshore Voluntary Disclosure Program that allowed willful evaders to come into the U.S. and come into tax compliance with the U.S. That system will be revoked effective September the 28th, 2018. Okay. And so if someone is willful, if their non-compliance is willful, oh, hello, Orwellian now. Because this is actually a critical point, it should be Orwellian. If someone is willful, it's a willful evader at that point, it's willful, hasn't filed tax returns or FRs or whatever they need to file here to bring themselves into compliance with the U.S. system, it's going to be, they're not going to have that ability to do so anymore. And even if the client says, okay, well, I'll wait till September to do this, or give me some time, frankly, the time is now. All the good law firms right now, I don't do offshore voluntary disclosure programs. I consider it criminal tax work. I'm a civil guy, okay? I'm a civil guy that operates under civility. So, but from that perspective here, the good law firms, the criminal firms that handle the work, they're booked up now. I mean, because one cannot just go to the IRS on September the 27th, 2018 and say, I want to file, here's my placeholder filing. No, you have to have a complete submission. The clock is ticking, right? So you're talking about telling somebody here, if you want to renounce, we're going to have to go in and negotiate a settlement with the IRS. We don't know how long that will take, and then we will discuss renunciation. And so from that perspective, the individual might say, I don't want to do that. Let them find me. And at that particular point in time, it is something to consider whether or not that individual should still be your client, and particularly if they're that far away from coming into tax compliance, renunciation is going to be 2-3 years down the road to even consider. So I'll speak before to the two of you, Ellen, but there's another point to bring into play.
The other thing to consider, Ryan, is that there are rewards given to, you've heard of this case in 2008, they lobbied UBS, LGT, which is Sign Bank. So all these Swiss banks, if you have an offshore account, they turn you in. I think this guy Berkeley got $108 million US for turning you in. So if you say that don't you just forget about everything, unless you've done things in such a way that no one knows you're American, but if you were born in America, that's a dead giveaway. You want to open a bank account anywhere, you have to know your customer rules. They'll say, you were born in the US, show me a certificate of loss of nationality. Otherwise, we're not going to allow you to open up a bank account. And furthermore, we're going to turn you into the IRS.
What about if I just move every single thing I have to one of my friends who is not a U.S. citizen, and they can keep it. I trust them and everything, and we're members of the country club together. And then maybe I'll just say I lost my passport. Maybe I accidentally got rid of it. I'll just use my passport I use for other countries. Wouldn't that work?
You mean a sham transaction?
Well, in the United States, CBP may say, hey, there's a federal law that you're supposed to use an American passport. Unless you can show me you're not a U.S. citizen, I'm not going to allow you into the U.S. So you're never going to travel to the U.S. again?
I don't know. I like that house. And
if you don't do anything, that's called the ostrich approach. It's a time bomb. So you could you're a young guy, you should clean it up, and then give it up.
Well, Mr. Cartwright was mentioning to me, you know, the process of renunciation based on someone like me that has, you know, my tax bill is not cleanest, I'll admit that. It could take, you know, a couple of years down the road, right, Mr. Cartwright?
Well, it could, but let me. I'm all doom and gloom, right? Because it's nighttime here on the East Coast. But let's put a little ray of sunshine into place. It's very possible that the individual could be, their non-compliance could be non-willful, and there's two ways really. The first way is sort of going away right now, and that is they just didn't know, and until they had a consultation with Eugene and me, for example, they didn't know. They just thought, okay, I'm paying taxes in my home country here. I'm not living in the United States. Almost all first world countries tax on the basis of residency only. On residency, not on citizenship. So, you know, I just didn't know. That's one. Now, the IRS has been engaged in a concerted information initiative over the past 10 years since UBS, particularly since UBS, to be able to dispel that myth. But there's a second method, okay? We went to another firm. We went to the firm of Barshop and Associates, and Barshop and Associates told us, oh, it's okay, okay? You didn't have to file, okay? And so I relied upon Barshop and Associates. We still see a lot of that. Of course not Barshop and Associates, but we see a lot of CPAs out there who think, I can say this, I can criticize CPAs because I am one. Okay, first and foremost, but CPAs out there who think, and other accountants, enrolled agents particularly, who think that the mere fact that they have international clients means they practice international tax law. That is a myth, complete myth. Okay, so they don't know, and they give them advice that is flat out wrong. Okay, it's incorrect, and they rely upon that advice. Okay, and then they come into your office. That's non-willful non-compliance. You know, and you can come into compliance there, and we bring people into compliance within 90 to 120 days while renunciation is going on. Okay, so if someone has that, you know, is able to go into this program known as Streamline, we do a Streamline review to make sure the individual qualifies for Streamline, and then, you know, at that particular, if they do, then we do an exit tax analysis, and then we're able to, you know, put them on parallel tracks. And so the tax compliance work can go on while the tax compliance work can go on while the renunciation is in place. Because I have until, you know, probably October the 15th of the following year to get the tax affairs in order. That's a lot of time, you know, to have until October 15th of 2019, as long as I can do this under the Streamline program, meaning non-willful non-compliance. Either I didn't know, or I relied upon some doofus who told me I didn't have to worry about it.
Clayton, while we're on that topic here, I've heard that from people, you know, at the country club, that the federal government could take away my passport if I owe more than $50,000 in taxes. Is that like a fairy tale?
Well, no, it's not a fairy tale, but it goes to a levy or lien. And so, I mean, to the extent there is a levy or lien, you're not able to obtain a passport or renew your passport. That's true. The question is, are you at that, you know, have you gotten to that moment, to that particular moment? And I'm not one to say to individuals, okay, it's, you know, don't comply or don't worry about it because it's rarely enforced, but I haven't seen it. Eugene, have you seen it? Because I have not. I have not seen the threat of that. Particularly clients that come to me at that point, they haven't gotten to the point of levy or lien, because if they have gotten to the point of levy or lien, I can't take them into Streamline. I have to put them over into, you know, I have to send them over to a criminal tax lawyer to handle either offshore voluntary disclosure or negotiated the negotiated settlement. Because once the government tells you you're on the hook, buddy, for this tax bill, you know, you don't have Streamline, or you have to go in and negotiate it at that particular point in time. And so you're not even at the point of levy or lien.
I haven't seen the plan deny the extension of the passport because of the tax lien, But I do have clients applying for alternative citizenship and the due diligence of acquiring the other passport. Some countries in the Caribbean, for example, are very afraid of the U.S. And even though there's a legitimate dispute, just like our President Trump, fine is under audit, is in tax court litigating. He's a hedge fund portfolio manager. He has a legitimate dispute with the IRS as to whether something his uncle gave him is a gift or income. And he spent like $250,000 US in legal fees for a tax lawyer litigating the issue. And I was trying to get him another passport because the only passport he has is an American passport, and the Caribbean country involved, will be nameless, is so scared of the US government that they just said, why don't you pay up? I said, by that theory, why don't we pay up all our obligations and mortgage on homes, cars, everything? Because US does carry a big stick. And the fact that you give up that passport and rely on another country's passport, they may not even give you another passport.
Okay, so suppose I hire the firm of Cartwright Chow, and Mr. Cartwright comes up with taxes. Makes it all nice, whatever the fees are, Mr. Cartwright, I'll pay. Although if you could take American Express, that'd be great, so I get points. Like that. But if you do clean up the taxes, let's just say my tax bill is clean and you give me the go-ahead, I can, everything good, go. And then I continue to retain the firm of Cartwright and Chow to get rid of my citizenship because I don't feel like I want to be an American. What would the process be, Eugene, to formally terminate my U.S. citizenship?
Well, different consulates work differently, and I think you have to pick your consulate. There is an advisory opinion from Ed Battencourt, he is now retired, that said that you can go to any consulate anywhere in the world, subject to workload constraints, to give up your passport. But some consulates are not as friendly as others.
Right.
But you have to fill in a lot of State Department mandated forms, and then you will be interviewed by a consular officer. And just like buying a refrigerator or some consumer good, you have a few weeks to think it over, reflect upon it, and then come back in again. And if you still want to go ahead with it, you'll be given an oath of renunciation. They'll write up a report, and then they'll send it in to the State Department, and depending on the post, some posts, like, somebody contacted me from Manila, it was like a year, they didn't get anything back. Other posts are very efficient. 2-3 months, you'll get a certificate of loss of nationality, retroactive to the date that you took that oath, and you're no longer an American. Then you're free to apply for a visa to go back to the United States.
But suppose I have a passport from a visa waiver country. Do I just fill out an ESTA, or do I still apply for a B-2?
Unfortunately, the software for ESTA is such that when you check off that you were at one time an American citizen, they make you go in to submit to an interview. And the same thing has happened recently to the BS-160 form. What happens is that the computer will say that you cannot proceed unless you check off you were an American citizen. I pointed this out to the U.S. consulate in Hong Kong. But, sometimes it takes the State Department a year longer. But basically, as soon as you check off that you were an American and you had an American passport in time, they won't let you fill in the rest of that form. So you have to say no, and the lawyer should write a letter saying that, look, we are not trying to make a material misrepresentation as to whether our client was previously an American. It's just that your software says error. You cannot proceed once you check out you're an American, because evidently the State Department thinks that everyone that's American should be entering the United States, and there's no provision for someone that was formerly American. But Hong Kong is aware of it. I think it's been brought to the State Department's attention, and eventually, you could finish the process and answer everything accurately.
When you mentioned the letter, are you talking, I have to give that to the U.S. consulate in Hong Kong, or the U.S. consulate anywhere, or do I give it to the border police upon arrival?
Well, I make sure that the client says to the consular officer, I want this letter to be to be scanned in as part of my visa application form, because I don't want to have a hassle on the entry with a CDP officer who says that I lied, that I previously was American, and I didn't disclose that when I applied for my visa.
Okay, well, I do have to make an admission here. Yes, I did commit, several, violations of the law, over my 39 years of existence, and, 39, and, but no one knows about it, at least for now, because I've been getting out plenty of hush money as part of the deal I have. What happens if I do give up my citizenship, and later, down the road, they find out about these crimes that I committed? Could I be banned? I mean, or would no one really care?
Well, it depends on what kind of crime it was. I have a case right now involving a very simple marijuana charge. And, if you're an American, as I said, you could be a triple X murderer. But, if you're a foreigner knocking on the door, you could be a prominent lawyer, barrister, you could be listed company director. If your indiscretions, the youth days come back and haunt you.
Okay. It's a lot to think about right now.
One thing I want to add here too. I mean, I want to just backtrack for a second here about a point that Eugene made, and we're talking about we're going to talk about in terms of venue. I mean, some countries do not allow for dual nationality. Okay, and then if the individual finds out that they're an accident, I think Indonesia, for example, is one. If you find out that you're actually, this is a live example of a case I had a few years ago, where we actually considered trying to go into Hong Kong because the client did not want to walk into the U.S. Embassy in Indonesia and give up their citizenship because they didn't want to be seen in broad daylight doing so. I mean, strange enough as it is, they didn't want that to happen. And so eventually we convinced the client to go ahead and do that. It wasn't worth the transactional cost or anything like the sort. But keep that in mind that there are also home country concerns that we have to deal with. The other one is the issue of statelessness, right? I mean, this is an issue that I know our colleague Richard Goldstein, for example, who couldn't make it here. I mean, he preaches a lot about this. I agree with him. I mean, technically, you can become stateless, under the fan. But you try going to a U.S. embassy and try to become, and try to give up your U.S. citizenship and become stateless. It's not going to happen. They're not going to receive you. I mean, we ask this question. I go around and speak a lot with the RDC, a lot with BDC, and you don't get. Generally, the answer is no. And so many times we have to, deal with it to the extent that the individual is moving to another country. We have to make sure that that the naturalization process is happening in the other country, right? To the extent that the embassy is satisfied to allow for the renunciation to prevent statelessness.
There's a Board of Immigration Appeals decision that says that the U.S. is not a signatory to the UN protocol against statelessness. So you can become stateless if that's your choice. It's one factor for the State Department to consider in deciding whether to approve the certificate of loss of nationality. But that said, we had a battle in Hong Kong because, again, it depends on who the American Citizen Services Section Chief is, whether you can convince that person that you're right on the law, and whether they want to send it back to the visa office for their advisory opinion. So you want to give up your passport in a country where a lot of people give up citizenship. It's not unusual for consular officers that have spent 15, 20 years, in different posts in the world where everyone covers an American passport. And it's not unusual for 15,000 American immigration lawyers. I dare say maybe only a dozen have actually ever handled an expatriation case. Everyone is so fixated in the American Immigration Lawyers Association helping people go into America. They don't realize that for many people, they want to exit and live elsewhere.
On that topic, Clayton and Eugene, here's a hypothetical that I've had a colleague handle before. A situation such as, suppose we have an American citizen who has had children in the United States, children abroad, the children receive their consul reports of birth abroad. The U.S. citizen and expatriated receives his lost certificate. Would that child still be eligible for a CRBA, or is that not possible because they were not a citizen at the time of the birth?
If the child was born when one of the parents was still a citizen of the United States, that's November 14, 1986, it's the time they changed the rule. So if you have 5 years in the US, 2 of which are after the age of 14, your child would still be a citizen, even though you gave it up. I've had clients give up their passports, and later, when the child wants to study in the United States, we've gone back to the US consulate, applying for the passport, saying that I didn't come in for my CRBA at the time because I didn't think it was important, but my dad was an American at the time of my birth, so the child would still be qualified for citizenship. But
Not at the time of, no, if the child was born when after the US citizen parent renounced.
then there's no transition.
But Ryan, I mean, you raise a very critical point here, one that we see often, and that is that when we're dealing with a child, and it comes up, of course, in the context of a child of wealth, and that is, when is the child subject to worldwide taxation on their U.S. income? And keep in mind that this isn't just any old child. This is a child who may have been gifted $10, $20, $30 million over the years, and it has a consistent income stream, or at least one that would involve significant U.S. tax compliance. It's not at the time. The misnomer is at the time of going out and proving up the citizenship. No, it's at the time of transmission. And there's a very, very simple. It's a very, very simple reg. It's very easy to remember. Internal Revenue, Treasury reg, under section 1 of the code. Section 1. Okay, easy enough. Okay, 1 is the loneliness number, and it's true in this case here that it defers to the INA. So one cannot say that, I don't have any tax obligations to the United States because I didn't pursue my U.S. passport until I was age 19, until I was age 20. Okay, it starts back to the point of transmission. That's when it occurs. And so it's very important to keep that in mind, because sometimes you'll have a client like this who'll come into your office and say, if I have U.S. citizenship, I'm going, if I pursue it now, then it's going to trigger tax consequences. Either it was transmitted or not, regardless of what happens, they still have a tax problem if they haven't filed returns, and then we're supposed to.
Boris Johnson, for example,
a good example.
That he's a British national. He just happened to be born in New York City. But eventually he expatriated. He had to pay an income tax on the capital gains, even capital gains on the residence he owned in the UK. And it doesn't matter that you never applied for the passport, as Clayton points out, or that you never registered your birth. If you are, you're either pregnant or you're not pregnant. So if you're a citizen, you are a citizen, even though you don't have the evidentiary proof that you're a citizen, such as a birth record or a CRBA or a passport or nationalization certificate. You're still a citizen, depending on the facts at the time of your birth.
Right.
Okay. So in that situation, we've covered a lot of information so far. To go further into our analysis here, when I address a situation like what I have is, I'm no longer going to be the arrogant, wealthy, accidental American. I'm actually going to be Ryan right now, the Secretary of the Bangkok District Chapter, who is somewhat professional. I'll try to be. Okay, I will try to be where the different background. In this situation, it's because I personally have handled multiple citizenship cases, multiple expatriation cases in my post that I focus out of. And one thing also to consider, we talked about second citizenship passports. I mean, what happens often, I've had this happen multiple times, is we had U.S. citizens who, every case I've handled has had second passports, but a couple of my clients have actually received citizenship through investment in an unnamed country. So far, they've had no issues getting their 10-year visitor visa, their citizenship, their country, their second passport is listed as 120 months, 10 years on the state reciprocity table. But could that still be an issue later on?
That's why it's very important to take the consulate where hopefully you're a resident of. I've represented lawyers in very big firms that make megawatts and who are now CEO of family offices and so forth. And even though they're lawyers themselves, they could be a good M&A lawyer, they could be a good, commercial lawyer. But in getting rid of the passport and getting another passport, some consulates or embassies are very prejudiced. As soon as they see a St. Kitts or a Caribbean passport, they say that, hey, you're one of those. You're going to put this case into administrative process. So it really, behooves the practitioner to be very careful picking the consulate and preparing the client, because sometimes, just reviewing on the tax returns that your base income is 150,000 US a month and the consular office maybe 75,000 a year could trigger prejudicial adjudication of the case, and the case will just get delayed. Luckily, in the deal, sometimes they can't get you on the 212-810, and I had a couple of cases recently that went to the advisory opinions office. Again, it depends on the will of the consular officer. And sometimes it's not a rogue officer, it's just a new officer that has never been in a post where they've seen an American give up a passport. And they say, wow, you gave up a passport. And let me talk to my supervisor. He comes back and said, oh, I'm sorry, I can't give you a visa because you're inadmissible under 212-810E. And it takes 6 or 8 months to go to get a legal net to get an advisory opinion back saying that, hey, the role of the consular officer is very limited. They never had implementing regulations to 212-810E. And, Ryan asked me to write an article, which I did, which is in the materials, because so many immigration lawyers in the U.S. is fixated in helping people get green cards, getting naturalized. But there is a lot of law on this subject, and consular officers are not supposed to take the lead role in making a finding of inadmissibility. They're just the messenger to pass it on to Treasury, and DHS is the agency that should be making that role. So this article summarizes, and I think that Senator Schumer tried to pass a expatriate law to have a presumption that if you have a certain net worth, you pay certain taxes, you're presumed to be inadmissible, but that never got anywhere. And we still have a country where, there is a choice. But many Americans that practice only in the U.S. think that only fat cats are trying to get out of the U.S. tax system. And there could be a school teacher, it could be people that have been living abroad, they've settled, they got married. But, sometimes Hong Kong, for example, takes 7 years to become a nationalized Hong Kong SAR passport holder. And that's why in the interim, some clients choose the Grenada or, St. Lucia or any of these passports because they don't want to wait 7 years of residency to acquire another passport. The other thing is that, it's a catch-22 because Hong Kong won't give you the passport for you to get the certificate of loss of nationality. And at one time, the U.S. consulate here said that we are not going to allow you to expatriate until you prove you have another citizenship, which is against what the family says. And it's been clarified in the Board of Immigration Appeals decision.
Yeah, just to clarify, to emphasize what Eugene stated, not everybody who's getting up their citizenship is a bad cat. I mean, there are many people I've actually been my clients who are ordinary people. We're talking, they work for the government, so they were government workers, they have a small pension, and they give up their citizenship not so much for tax purposes because they just have no ties to the United States. They left when they were young, they lived abroad, they come back.
Right.
Yes, twice.
Yeah, right. If I may, I wanted to say there's a critical issue with that, though. I agree that they're not giving up; they may not be giving up for tax purposes, but the often I see this all the time. I don't make enough money, I don't have enough net worth, so the tax issues don't apply to me. Big misnomer, big issue that's in place. Yea, verily, the transactional costs as a percentage of their net worth may be much disproportionately higher. they may require the same amount or a similar amount of work as a fat cat to bring themselves into tax compliance because they're just darn unlucky in terms of where they have their money. So it's very clear here. So if someone says, well, gee, I don't make a lot of money, and I don't have high net worth, I don't have to worry about the U.S. tax issues, that's not true. And that's from a practical standpoint, from a practice management standpoint, that's a very difficult position. It can be a difficult position to be in as an advisor on expatriation to tell you, no, there's no de minimis rules. I mean, there are certain rules to trigger the exit tax, but bringing yourself into compliance, you may be paying. You may be paying a significant amount of money compared to your income to bring yourself into compliance, and that's a very hard spot for that person to be in.
Oh, Clayton, also just to emphasize that, I mean, I understand, but there are people who are given citizenship. Nothing. I mean, yes, the tax, the financial consequences do not go away, but there are people who are giving it up just because they have no ties. I mean, for whatever reason.
Agreed. But when if you're going to process that and you don't advise them on the tax issues, and for whatever reason, that pops up, there's a tax issue, then you are going to then you're going to run into. I think we're running close to time, right? So I'm just making this point. They could potentially come back to you and say, "You didn't advise me, pal, about the tax issues." Okay, and so just keep that in mind for whatever reason, because because they're inherited money, you've got other issues that pop into place. So you don't want that to happen either.
Okay, I think we're back. Okay, yep. 5 minutes. Okay. Okay, so thank you, Clayton, on that. Eugene, you anything to add? Well, I could, we can do a show of hands. We want to take 5 minutes. We want to adjourn. All in favor of 5 minutes?
They're not hungry. Any questions?
All in favor of adjourning?
Any questions?
Or we go for questions.
Oh, no,
Yes.
it's adjourning.
Any questions before we adjourn the 2018 day district conference? Any other questions before I adjourn the panel? All in favor of adjourning the panel?
Aye.
All opposed? We are adjourned.
Thank you, Clayton.
Thank you, Clayton.
Thank you for the dispensation, everyone. I really appreciate it. Thanks for allowing me to participate via this remote access. Very much appreciate it.